January 1st, 2009, according to the United States Department of Justice Bureau and Justice Statistics, on any given day, there are 234,000 convicted sex offenders. The Violent Crime and Control Law Enforcement Act was created in 1994. This law is also known as Megan's Law. Megan's Law was created after 7-year-old Megan Conca was raped and murdered. Her family had not known that a convicted sex offender had moved into the house next to their family. This law is important because it helps people know of sex offenders in their neighborhoods and gives the family the advantage of keeping their family away. Under federal law, Megan's Law requires all states to adopt laws requiring convicted sex offenders to record information with local law enforcement agencies. In addition, the law requires that the law enforcement release all information to the people. Although this is required, each law enforcement agency may choose to what extent if information is released, from not releasing it at all to releasing everything. Each person should be able to know if there's a sex offender where he or she lives. This is why our proposition is, Megan's Law should be standardized as a nationwide policy. Now, to standardize, we want to make legal terms of Megan's Law the same across all states, and the release of information of sex offenders should be the same no matter what happens inside the tier. So my first significance claim is, sex offenders who are assessed as low risk or Tier 1 have a greater likelihood of reoffending. A Tier 1, simply defined, is a low risk of reoffense. A Tier 2, a moderate risk, and Tier 3, a high risk of reoffense. All the tiers include other factors such as status of therapy, criminal background, facts that were in the case, and psychiatric profiles. My evidence number 1 is, just because a sex offender was required to record his information with law enforcement, it does not diminish the want for sexual misconduct or lewd acts with children. In an interview done by Tatiana Morales of CBS with Jake Goldenflame, author of Overcoming Sexual Terrorism and a former sex offender, Jake said, "We medicate our depression with sex, with forbidden sex. Because the moment I decide I'm not feeling good today, why don't I get myself a good-looking teenage boy or girl, or whatever you're after? The moment you think of that, you start getting high." He goes on to say, now the depression vanishes. You're in the throes of things, and it begins to call you forth, and as you pursue your prey, you become more and more intoxicated. It becomes a very intoxicating experience, and then afterwards, after the sex act is over, it all comes crashing down. Oh my God, what have I done? Our next evidence, in California, it goes even further than not recording information. In December 2004, the California Department of Justice made available Megan's Law public internet website. This website displays photos of the person, offense details, and allows you to find out what county the person lives in. This means that no one is required to know what level the sex offenders are, but rather your average person must want to inquire and learn about the information of the sex offender. Second significant claim is Megan's Law is more focused on punishment rather than protection. By Derek Loeb, the book Once Fallen, he states that the current law is promoting violence among people and offenders. Nearly half of the offenders reported experienced threats, property damage, or physical assault as a result of public disclosure. In addition, almost half the people living reported being threatened or harassed by neighbors, 27% had their property damaged, and 7% say they were physically assaulted by someone as a result of notification. In a 59-page report done by Kristen Zagoba, Philip Witt, Melissa D'Alessandro, and Bonita Vese, they quote that Farkas, who wrote a book, also found that the majority of sex offenders reported bad consequences such as exclusion, threats and harassment, emotional harm to their family members, social exclusion by neighbors, and loss of employment. Our next significance claim is standardizing Megan's Law will yield direct information to the people. If one were to take a look at Texas, the state has a 2.5% of unaccountability. This means that only 2% of all sex offenders, and as of May 29, 2009, that's 57,050 people, information is not released to the people. Texas requires law enforcement to put information of a state internet site, requires enforcement to put information of the sex offender on the site. Although all states have this, Texas is the only state that notifies the people directly through emails and postcards. It is mandatory for each law enforcement agency to send postcards to household if the sex offender is high risk. According to the Department of Criminal Justice Services, a high-risk sex offender is one who has a higher risk of repeat offenses and is a threat to public safety. A risk tier is based on court's assessment regarding whether a particular offense is likely to repeat and the danger to the community. Our inherent problem is that the details differ among states. Our first structural claim is the current law fails to keep sex offenders away from children. In California, local law enforcement must follow federal law, but once again, the discretion is up to the agency. Reported by Amy Angeles, a writer and reporter for Good Housekeeping, she reported on the story of Brian McDaniel and Robert Forzano. These two men had met in prison, but once they were released, got a house together next to a family. The mother, Francine Johnson, who was neighbors to McDaniel and Forzano, had recently noticed the two men had been playing quite a bit with the children. Now, what was particular is that these two men were very unsocial. They always kept to themselves. But they were throwing pool parties, inviting them to the house, using snacks and soda, and become very friendly with them. Not until the school alerted authorities that the kids were skipping school did some action go into effect. Officer Steve Wright decided to learn some information upon Forzano and McDaniel. Mr. Wright learned that Forzano was a convicted sex offender and had been showing pornographic images to one of the children, who was 9 years old at the time. Not only until this moment did the police take any action. A few details that existed for both men. Sergeant Links of the Rancho Cordova agency reported that it was pretty scary to see that these two men had more Walt Disney movies than parents. Links also found movies of the children urinating and undressing. Forzano was charged with 2 felonies of molesting or annoying a child under 14 and a misdemeanor for using a camcorder to record children for sexual gratification. McDaniel was arrested for having child pornography. Our next structural evidence is the current law fails to deter reoffense. A study conducted by the New Jersey Department of Corrections and Rutgers University sought to prove the non-existence of deterrent in their state because of Megan's Law. This 44-page study was to prove that Megan's Law is failing to prevent first-time or reoffenses. The study enrolled 550 sex offenders who were split up into 2 groups, those who committed sexual offenses before Megan's Law and those after the law. In the group of offenders before the law, 10% were arrested on same-sex crimes. The group after the passage of the law found that 6% had been rearrested. Although I cannot find any statistical evidence, researchers noted that there is a deterrence, but this deterrence had been happening even before the passage of Megan's Law. Our solvency is through train of reasoning. The current law regarding Megan's Law proved inconsistencies among almost every state, from tiers to release of information, to days recorded after release from jail, from punishment to not recording the information, and to even what a sex offender is. By standardizing Megan's Law, the tiers would be more exactly defined. The information released would be according to tier, the time allotted to record information would be exact, and what a sex offender is would be defined. As always, there's always an exception to the rule. The standardizing of Megan's Law would rid of the inconsistencies within the current system among states and allow for a defined law for all offenders. Our plan of action is to define what a Tier 1 offense, a Tier 2 offense, and a Tier 3 offense is. All tiers will include the likelihood, as the current system does. Other factors such as psychiatric needs, therapy needs, severity of crime, age of victim will be taken into account. For a Tier 1 offender, they would only have to release their information to law enforcement. Their information should not and cannot be released. That includes mooning in public, stalking with sexual motivation. A Tier 2 offender would be required to record the information with local law enforcement, and they may choose to release information if it's a low risk or a high risk Tier 2. This is kidnapping with sexual motivation, abduction with sexual motivation, any prior conviction higher than Tier 1. A Tier 3 offense includes rape, sexual battery, murder with sexual motivation, kidnapping a minor to engage in sexual activity. This is just the tier system. At least now within the states, there will be a consistent law for how information is released. It will not be up to each enforcement agency on whether they think information should be released. It will be required. Thank you.